Right, well, thank you for that introduction. I'm sorry I'm late. The other role I have as Leader of the House, which does cause some disruptions from time to time. So if there are bells ring and I have to go, this will all be available on a website for you to read in the quiet sanctity of your study. And you can hear me at the back. Good. I've got a country electorate in WA, and I asked that question at a town hall during the campaign, and an old farmer said that he could hear me, but that he was happy to swap places with someone who couldn't. It's a very tough job, politics. Thank you very much for the opportunity to address you today, and obviously I'd like to pay my acknowledgements to the traditional custodians of the land on which we are meeting and speaking today. I think when you come into a new portfolio, it's obviously a very good habit just to read everything that you can read. But also, I've gotten into the habit of trying to describe what I'm looking at and the landscape in a sentence. Just to myself in my diary, and my earliest observation about the IR landscape was that, firstly, industrial relations is obviously very important to the Australian economy, and secondly, that it has a history of being a very highly contested policy space and often a very controversial policy space. Now, that would seem trite, but I think it's a useful starting point for any new minister, and it's obviously a very, very coarse summary of a very complicated area of the intersection between the law and the economy. But even if it's an inelegant summary of the industrial relations space, it pointed me directly to the two central questions that any minister has to ask themselves in this area. The first is, of the range of conceivable, possible legislative or systemic or administrative changes that you might be making, what are the most important of those? So what kind of triage are you going through as early as possible and as crisply as possible? And the second question is, of your triage list of possible things that you might think are very important, what are the changes that are actually possible? In the sense of what possible changes can you achieve a significant enough degree of consensus to have the public support to move something through Parliament and through the Senate. And I've had very constructive and healthy relations and conversations and negotiations on other matters with the crossbench. They are a sensible bunch, and I think that if you can build a public consensus, it's a very good indication that you might be able to move something through the actual Parliament. So they're not always simple inquiries to resolve those two inquiries, and I wanted to start by relaying an event to you that occurred this week in the Senate, and I think it illustrates how small things can have a massive impact, how it's a very contested space, and how ultimately you have to deal with the Parliament and with the Senate. And in terms of that unknown territory that we seem to find ourselves regularly in after this or that decision of the Fair Work Commission or the Federal Court, this is a good example. So late last year, the government made a regulation to provide clarity to small and family businesses about the potential and very unexpected liability that arose from this so-called double dipping issue. Now, that liability was estimated by many plausibly in the business sector to potentially represent $8 billion worth of cost to business in Australia. $8 billion. And obviously the issue arose from claims by class action law firms to pay casual employees for annual leave, even when casual employees had already been paid a 25% loading, and that loading is expressed as being to compensate for not having an entitlement to annual leave. So it was a very unexpected interpretation and decision. Now, the regulation that we brought into the Senate simply reflected what has been the long-standing existing legal position and practical position, long-standing for decades, that when a payment has been paid by way of the loading and is later found that a payment for annual leave is payable, that the employer can offset that liability by the payment it has already made. Fairly simple stuff. But unless a rule like that exists to clarify the situation, the potential cost of business would have been upwards of $8 billion. Now, I think that's a very fair and common sense position. It avoids businesses having to make double payments that could have been quite crippling for many businesses. On Monday of this week, the opposition sought quietly to remove that simple protection by moving a disallowance motion of that regulation. So late at night in the Senate, I think fair-minded, simple, reasonable regulation to clarify the position which has always existed in Australia was subject to a disallowance motion, and had that disallowance motion been successful, the cost to the businesses in this room and across Australia would have been $8 billion. And that occurs very quietly in the evening in the Senate. Now, as it was, that opposition motion to disallow failed because we had the support of the Centre Alliance and the Crossbench and One Nation. So it is a very finely balanced area. and great care needs to be taken. So, as to the contestability, even a very cursory examination of the history of Australia's industrial relations system and law reveals this revolving door of policy in this contestable space and the instability that that can occasion. And I think so much of the contestability in this area arises from a simple but, in my view, very, very mistaken conception of the industrial relations system as a contest. That is a very false observation, in my view, but it seems to underride so much of the debate in this area. And that false view is to conceive of the IR system as this perpetual contest between employers and employees. And I think that there's actually probably no other area of economic and legal policy where that zero-sum game conception is less reflective of the real-world conditions that we face and the actualities that we face than in industrial relations. There are significant opportunities for change that can benefit both employers and employees because they can grow the economy, grow jobs, put pressure on or directly lift wages. Now, obviously, the tricky part of this portfolio is to identify what those potential changes are and can be, and to try and build and reach sufficient agreement around them in the marketplace of ideas and in public debate that there is a passage legislatively through the Senate. And many of these changes might also involve administrative changes, but they likewise need to have a consensus built around them. Now, as I say, that is a not necessarily simple thing to do, but one point worth making is that the starting point for considering potential improvements in the IR system is far from terrible. Like, where we are now is far from terrible. There is some very significant common starting ground. I think there's now general consensus around some important core features of the system. A single national industrial relations system for the vast majority of Australian workplaces. The system has been transformed from one based on arbitration to one based on agreement making at the workplace level. There's now, thankfully, very little legal tolerance for industrial action outside the enterprise bargaining process. We have a minimum wage system where the minimum wage is set independently from government, which is measured by the OECD presently as the highest in the world. So casting your mind back to debate about the minimum wage and a living wage during the election, we have an independent system of setting the minimum wage. The Australian minimum wage is the highest in the world. The award system has been simplified. Yes, I know it is still complicated, but it has been simplified by the creation of 122 mainly industry-based modern awards. They replaced thousands of awards previously. So there's some work to do there, but the system is simpler. The safety net underpinning enterprise-specific agreements now comprises the 10 national employment standards in the Fair Work Act and the relevant industry awards. And there is very strong freedom of association and remedies to address discrimination and unfair dismissal. So I think the present system benefits from a single great virtue that in most sectors, at most of the time, it is a relatively orderly rules-based system. And that has to be the starting point for any system, including industrial relations system. In my observation, a central reason why the radical ACTU Labor policy platform at the last election in this area of industrial relations was so spectacularly unsuccessful was that the Change the Rules campaign was seen by the Australian people for precisely what it was and precisely for what it was not. And I think that the Change the Rules campaign was not an acceptance of the fundamentals of the present rule-based system and then an effort to look for sensible changes inside that rule-based system that could benefit everyone. Rather, I think what it was in actuality was an agenda suggesting wholesale replacement of one set of rules, the current set of rules, with completely foreign and radical policy prescriptions such as a move towards direct taxpayer subsidy to produce large wage increases in cherry-picked industries and areas of the economy by processes that were never stipulated, set out or described to the Australian people. That would have been a very, very radical change to our industrial relations system. And I think most telling of all about the failure of the Change the Rules campaign is that the version of the rules that the union movement and Labor leadership at the last election wanted to radically change and replace were essentially the Labor rules established when Labor were last in government. Indeed, essentially instituted by a fellow speaker at this conference, Julia Gillard. So I think one thing Australia wants to avoid is wholesale, radical, uplifting change that changes the landscape entirely. I think that's not what Australians want, and I think that's why the ACTU's Change the Rules campaign failed spectacularly. There are two areas where there is a demonstrable need for improvement immediately, like right now, in the industrial relations system, and I would submit to you that they are represented by the two bills that are presently before Parliament and which have been the subject of enormous debate, enormous scrutiny, and which will be voted on very shortly in the Senate. The first of those is the Ensuring Integrity Bill, and the second is the Protecting Worker Entitlements Bill. So both those bills are simply designed to allow more reasonable and timely responses to known instances of lawlessness and corruption in the industrial relations system. They modify standards rather than introduce new standards so that the government can properly respond to instances of known and persistent lawlessness and lack of transparency. Now, if you think that there is a need, then you'll be in agreement with the government on this. If you don't, read federal court decisions. When Justice Mortimer of the Federal Court observed last week, in handing down yet another penalty to the CFMEU, this time for faking safety concerns at a school, a building construction site for a school, he said, "The level of contravening conduct can only indicate a continuing readiness to disregard and flout the industrial laws of this country when it suits the CFMEU and its officials to do so." That organisation has famously been described by another federal court judge as the most recidivist corporate offender in Australia's history. The most recidivist corporate offender in Australia's history. Yet another judge recently said, and I'll quote his words directly, "The CFMEU, and in particular the Victorian Construction Divisional Branch, has an appallingly long history of prior contraventions of industrial law. There is no evidence before me of any compliance regime ever put in place by the CFMEU to address its long history of prior contraventions." Now, when you have judges saying that to the government and to the people of Australia, you can't do nothing. And a more reasonable standard to respond to that sort of indentured lawlessness has to pass through this Parliament, and it would be very important indeed if you shared that view, to put that view to crossbenchers politely and democratically. But the CFMEU's record, and this is from someone who was a former prosecutor and has been involved in watching people break the law for decades, the CFMEU's record is truly and astonishingly appalling. I have never seen anything like it. 2,166 separate breaches of the law in the past 15 years, an average of almost 3 per week, over 16.5 million in court-ordered penalties. That's just for breaches of the industrial law. That's just for breaches of the industrial law. It doesn't include the serious criminal offences that the organisation and its officials have been convicted of in recent times, including drug dealing. Now, the response of the CFMEU to that astonishingly appalling record was evidenced on radio yesterday morning by John Setka, and he essentially said that they're all minor transgressions of right of entry laws, and that all of them, those transgressions, were designed to try and improve health and safety. I've got to say that is a thoroughgoing nonsense. I mean, it is just nonsense. What we're talking about is blatant, repeated breaches that actually undermine the health and safety at building sites. We're talking about coercion, intimidation, securing a culture of bullying and harassment where the union gets its way, or employees and employers pay the consequences. That's what we're talking about. Now, if I give you just one example of those 2,166 breakings of the law, there were proceedings commenced in Queensland last December against a CFMEU organiser for his behaviour towards Queensland Government Occupational Health and Safety Inspector at a Cairns Performing Arts Centre site. And it's the community that ultimately pays the costs for that sort of behaviour. But if I can tell you that the response to the CFMEU's behaviour towards a Queensland Government employee was that the public sector union in Queensland that covers the health and safety inspectors now has a list of the top 17 largest construction sites in Queensland that they will not allow their health and safety inspectors to go to. Right? So one union is so afraid of the CFMEU that it will not allow its health and safety inspectors to go there. So this is what we're dealing with, and it is a fundamental issue which we must deal with legislatively. The Master Builders Australia has estimated that infrastructure projects in Australia, such as schools, roads, hospitals, can cost up to 30% more due to this type of disruptive union, militancy and unlawfulness on construction sites. So this is roads, schools, hospitals, aged care that cost the taxpayer and the ultimate purchaser around 30% more because of precisely this type of action that we have been powerless essentially to stop from a very small minority rogue militant branch of one union in Australia. And for anyone who thinks it's just about John Setka, of those 2,166 contraventions of the law, I'd say Mr. Setka, as a fact, is responsible for just 22 of those, so about 1%, which means that 99% of the rest of the unlawful conduct is by people in the organisation who are not John Setka. So this is a systemic problem inside that union. The second bill is the Protecting Worker Benefits Bill. Now, what that bill does is provide transparency to worker entitlement funds as recommended by the Trade Union Royal Commission. Now, the idea of those funds, of course, is to keep safe the money that might be needed in the future for potential workers' benefits like severance entitlements, and where the capital generates interest and the funds have money beyond the contingent liabilities to pay for a future worst case scenario event, the interest can be used to fund programs to the benefit of workers. No problems whatsoever there with that. That's a fair and reasonable administrative system. The difficulty is that in key areas, the theory of that system is not the actuality of what is going on. And I'll give you an example of that. There is a fund which I'd say is euphemistically called Protect. That was established by the ETU, the Electoral Trade Union in Victoria, and an employer body, NECA, the National Electrical Contractors Association in Victoria. This is the Victorian branch of that body. Protect, which is meant to keep safe the money for severance payments that might be needed in the future for electrical workers. Protect transferred in 2 years payments of $45 million to the ETU and over $15 million to NECA, the National Contractors Association. Now, that is on top of the monies that have been received by the ETU from Protect and other trust sources for administration fees, management fees, directors' fees, interest on these receipts, which we've calculated as, over the last 10 years, $125 million. And what has that $125 million been spent on? Well, the honest answer is no one knows. No one knows, because there is no proper, transparent, regulatory or accounting system around these funds. I mean, NECA, who received $15 million, listed the largest part of that amount in their annual report as going to improving the bottom line. No kidding. $15 million will tend to do that. But where is the $125 million worth of evidence as to how that money, that $125 million, is spent on the types of programs that might actually benefit workers? In addition, there have been numerous instances where the money is spent on programs that are allowable and accessible only to members of the union. So everyone's money goes in, union and non-union members, but only union members can get the services. There has to be a proper system of regulation around these funds. And the bill before Parliament would simply require proper transparency for what goes into the benefit funds, what comes out, how it's spent, and that we can all be assured in a transparent, orderly way that it is spent to the benefit of workers. Now, I cannot overstate the importance of those two bills. If you think that it's a compelling case for those two bills, and those two bills don't pass Parliament, that is pretty good indication that this is an area where there will be very little ability to grow, build consensus into the future. I think these bills are both such no-brainers that if they weren't to pass through Parliament, that would be a very, very bad sign for potential future mutually beneficial changes in this area. Workplaces in Australia will not be fair, high-performing places that drive job growth and wages growth if they're not lawful places, full stop. And if activities like those of the CFMU that I've described are allowed to go on and go on unchallenged, that will be the detriment of all Australia's employers and employees. Ultimately, what we all want, I think, is to see high-performing workplaces that sustain high-paying jobs in a competitive global economy. And as I noted at the outset, if we're going to make a change, we need to build the case. We need to be able to demonstrate that the change will deliver real and lasting benefit for all Australians. So if I'm correct in observing that that radical change of the rules campaign of the Labor Party and the union movement failed because it was a radical effort to enact wholesale changes of the rules rather than sensible piece-by-piece improvements, then the obvious alternative path for us as a government is to look at sensible, consensus-driven, piece-by-piece, issue-by-issue, case-by-case changes. For my spare time, I like to read philosophy, which I know I should get out more, but there's a great 20th century thinker who compared public policy to engineering, to physical engineering, and he noted that engineers refine machines through a series of adjustments to existing models. They look at what parts you can change to have the greatest effect on the outcome of the overall machine. And that thinker didn't see the phrase piecemeal change as negative or an inferior. He actually saw piecemeal change as superior to radical approaches because it allows a very strong triage in dealing with things issue by issue, looking at the areas that can have the most potential impact, and it permits a series of readjustments as you need that can be of overall greatest benefit. So in speaking with the PM, and he has said this publicly, the three criteria that any future reforms in this area need to meet would be: first, they will need to create jobs and put upward pressure on wages to benefit workers. Second, they must help businesses by boosting productivity. And third, we need to be able to demonstrate that the reforms will help grow the Australian economy overall. If we can build a consensus on those three criteria around a given change, then that is a change that we think is worthy of pursuing and possible to pursue. Now, the simple method of exploring the areas where a series of readjustments can have the most potential impact that I've determined on is by inviting submissions on a series of issue-by-issue, case-by-case discussion papers. One thing I think is very unhelpful in this area is to get an eminent person to go out and do an overarching review and come back with 172 recommendations that sit on a shelf. I think that you deal with this issue by issue because all the issues are different and the cases around all of the issues are different, and that you do this one stage at a time. Now, the issues that we are selecting and have selected are based on representations made by stakeholders, many people in this room, to me and generally to government and previous ministers over many years. Now, there have been many recurring themes that would be familiar to people here: complex awards, complex agreement requirement and making processes, delayed resolution of disputes, the unpredictability of decisions, as was mentioned, inconsistent levels of compliance, lack of flexibility, inconsistent meanings such as those for casual employment, inconsistency in codes, dealing with small business dismissals. It's a list long enough to mean that there's plenty of work to do here. Now, the discussion papers are going to do this. They'll describe the current state of the law, the issues at play, they'll identify general directions and options for reform, and they will ask questions of you, aimed at eliciting plausible information to assess the benefits of a change. And whilst it'll depend on the subject matter of the individual discussion paper, the papers are intended to be plain English, straightforward, brief, and they provide 4 to 8 weeks for comments and submissions. You can do that via the website, and additional discussion papers will be issued in due course. They will all place a heavy emphasis on garnering evidence. These will be evidence-based changes. So today I'm announcing the first two of these discussion papers. The first is with respect to penalties, and there will be a second discussion paper on penalties in the system. And as I've said, compliance and the rule of law lies at the heart of a fair system. Legal compliance is essential for registered employer and employee organisations. Now that is a principle reflected in the Ensuring Integrity Bill that I described earlier. The discussion paper that I've released today deals with penalties that might be imposed for various forms of misconduct, including the potential criminalisation of certain forms of worker exploitation. They're meant to be potentially changes that would complement existing offences for serious criminal forms of labour exploitation, including forced labour, servitude and debt bondage in the Criminal Code. But by way of background, earlier this year, the Migrant Workers Task Force, which was chaired by Professor Alan Fells, delivered a report to government. It highlighted the widespread exploitation of migrant workers in Australian workplaces. The government accepted in principle all 22 recommendations, and the majority of those recommendations in broad terms looked at the adequacy of the existing penalty framework the introduction or potential introduction of criminal sanctions for the most serious forms of exploitative workplace conduct, the adequacy of compliance and enforcement tools available to workplace regulators and the courts, and mechanisms to recover unpaid wages. So the discussion paper released today will focus on the first two of those items, and there'll be a separate paper dealing with the final two. But as a starting point, we recognise that in order to develop a more effective compliance regime, there are opportunities to amend the Fair Work Act to provide further protections for workers and to deter unscrupulous employers from doing the wrong thing. And to this end, we are in the process of drafting a bill to criminalise certain forms of worker exploitation. And through this discussion paper consultation process, we are seeking your views on a number of the aspects of that type of reform, acknowledging that it is a major step. And we want you to help us inform that drafting process. Now, it's important to be very clear here, this is not about targeting employers who make inadvertent errors and mistakes and who are generally trying to do the right thing inside a complicated system. Full stop. It's not meant to be targeting that area. Criminal sanctions, we think, and this is the point in the discussion paper that we want to elicit views from you all on, criminal sanctions would need to apply where employers engage in serious unlawful conduct that is clear, substantive, serious, deliberate and systemic. So we are looking at a smaller pool of the overall conduct that meets those types of criteria. And that, if we can do it right and get the balance right, is not only good for employees, but it levels the playing field for all the businesses that do comply and do their absolute best to comply inside a complicated system. Because at the moment, we've got the overwhelming majority of businesses trying to do the right thing, competing against some businesses in the same business sector who are doing the wrong thing and whose overheads are lower. So this is meant to be something that protects employees and employers. I look forward to your submissions, and you can come in direct through the website to my office, and there's representatives of my office here. What you say is very important in these issues. The second discussion paper, which I think is equally as important, didn't get quite as much media today, but is equally important, is around, we've called it the Greenfields paper. But the second issue deals with the length of Greenfields enterprise agreements. So under the Fair Work Act, a Greenfields agreement is an agreement that relates to a new business activity, project or undertaking prior to the employment of employees. Of course, as a West Australian, I've seen these on major projects, so you're all aware of the type of major projects that these Greenfields agreements pertain to and how important these projects are to the health of the Australian economy going forward. Now, at present, Greenfields agreements may be made between an employer or employers and a union or unions able to represent the industrial interests of a majority of employees who will be covered by the agreement. And in such cases, the parties must sign the agreement before submitting it to the Fair Work Commission. But critical to the issue upon which submissions are sought by this paper is that all agreements made under the Fair Work Act, including Greenfields agreements, must include a nominal expiry date, that is not more than 4 years after the Fair Work Commission approves the agreement. Now, while all enterprise agreements must include a nominal expiry date, the Fair Work Act does provide that enterprise agreements continue in place unless terminated or replaced. So in practice, many large greenfield projects will already extend beyond the nominal expiry date of their enterprise agreements. Where an agreement has passed its nominal expiry date, employees can access protected industrial action if bargaining has commenced for a new agreement and the action is authorised by a protected action ballot. So businesses, communities and governments obviously require infrastructure projects to be delivered on time and on budget. Like, that is the gold standard for governments, whether they be state or federal. And these projects often cover construction of much needed public infrastructure, hospitals, roads, schools, and they require complex long-term planning, and future investment in these projects will depend in large part on Australia being able to demonstrate an ability and track record of being able to deliver such projects without uncertainty about costs, including labour costs and project delays. So in this sense, the ability to predict the budget of the projects and deliver the projects within a reasonable budget is the key to attracting the investment that makes the projects go ahead in the first place, which grows employment and makes our economy healthier. Now, overall, industrial uncertainty and the impact of industrial action can add very significant costs and delays to major infrastructure projects, and many of which, of course, are funded by the taxpayer. And the Productivity Commission stated that any weakness in bargaining for a Greenfields agreement can have, in their words, potentially large impacts on major project investment in Australia. And the current arrangements, in again the Productivity Commission's words, pose risks for large capital intensive projects with urgent timeframes. Now, this in turn poses significant risks to job creation in Australia. So the potential benefits of longer project agreements include industrial certainty for employers and investors, potentially better wages and conditions for employees, and to the extent it encourages the making of greenfields agreement, improved engagement with enterprise bargaining generally, consistent with the Fair Work Act objectives, and the opportunity to generate higher rates of involvement in these types of projects, and so supercharge Australian job growth and the Australian economy. Now, there's always an alternative view. Conversely, some parties have expressed concern that permitting a longer nominal expiry date for these agreements decreases flexibility over the long term and would prevent parties' ability to adapt to changed economic and market conditions and other unforeseen events. But the point of these consultation papers is to expose the concept and the issue to the marketplace of ideas and public and civil Australia and test those alternative propositions. And I think that that can be a healthy, rational process, and if consensus can be built around it, then there is the potential for a passage through Parliament. And if, in my observation as a West Australian, having seen the importance of these projects to our economy, if you were able to get consensus around the idea that there is greater certainty through life of project, greenfield project EAs, that would be a very significant thing for Australia's employment and Australia's economic growth. So I strongly encourage you all to read the papers. Thank you very much for the time that you've given me today. I understand I'll be taking some questions, which I'm delighted to do, but these are the first two papers of many, issue by issue, case by case, rational discussion by rational discussion, and let's see if we can't get more job growth and a better economy. Thank you.
I'd like to thank Minister Porter for covering a lot of ground in that particular address. And we have a bit of a hard stop happening at 11, but I'd like to open the floor now for questions. We do have a couple here that have come through the app, but is there any questions for the Minister? Oh, we've got one over here. If I could just get you to state your name and try and keep the question quite succinct. Thanks.
Yep. Two. Is that working? Yeah, sure. Tim Dwyer, Sunshine Coast Council. Hi, Kelly. Mr. Porter. Mr. Porter, the unions have done a terrific job amongst other people in making sure the minimum wage in Australia is, as you said, one of the best in the world. I do find it a bit counterintuitive that through other actions they are increasing costs to the Australian taxpayer in many areas with regard to that 30% premium that some projects are bound to have to face. Have you got an opinion on why that counterintuitive nature of getting the minimum wage where it is and yet then doing things that take and dilute the benefit of that minimum wage?
Okay, is that, you got it? So this is how the structural cost increase works when you have unlawfulness. And so those estimates from master builders, and there are other estimates that exist. One of them is that there's an estimate that a road in Australia is 40 to 45%, I think it is, more expensive than a same piece of infrastructure in Canada or Europe. Now, some part of that is about the costs of getting capital, some part is about wage costs in Australia, but the estimates from the MBA, from Master Builders, is about the segment of the cost increase that is occasioned by disruption caused by unlawfulness. So it's staggering to think that you could have infrastructure 10, 20, 30% cheaper just by people obeying the law of the industrial relations system. And how does that work? Well, not work, is that the example that was in court last week, a $36,000 fine, the CFMEU faked a safety concern to shut down construction for an entire day on a construction site for a school to simply make the point that they didn't like the subcontractor that had been engaged in the project because they weren't one of theirs, right? And you're all attached and involved in industries like this. Think about the cost of shutting down a construction project for an entire day. And that's the cost that we can avoid by passage of this legislation. And there is obviously a very significant minimum wage in Australia, the highest in the OECD, but we've had wages growth which has been higher than inflation but lower than some expectations. And obviously we want to make our industries more efficient so that productivity increases. But a very simple way to increase productivity without changing any of the other variables in the equation is not lose tens of days to unlawful behaviour, which frankly is coercive and intimidating and bullying. And we've just got to stop it. And if we don't do that, then we've got problems.
Are there any other questions from the floor?
Morning, Minister, and thank you for your discussion. My name's Jim Frith. I'm from McConnell Dowell. We're a construction company that operates nationally. One aspect of this bill regarding integrity that perhaps you've considered that isn't coming through to me, and I think it should, is the construction sector's making great strides to try and improve the culture of the industry. And by that I mean making it a more attractive place for a more diverse workplace to exist. And it just strikes me that the situation that you've described as behind the legislation is something that we've got to work collaboratively to solve. And so I'd be supporting whatever moves the government can make to make the industry more attractive to a broader cross-section of the workforce.
Yeah, look, I mean, completely agree, and it's not just me taking it on board, it's been took on board. And looking around the landscape, there are industries where the union's relationship through the enterprise agreement making process with the industry is pretty good, like very constructive. So the SDA in the fast food industry, you speak with the major employers, they have a very good relationship with the SDA, it's constructive, it's sensible, and it creates a culture and environment where there is initiative by employers beyond the request by unions to look after employees. So, I mean, I was speaking with McDonald's the other day and they were describing how they encourage issues or information about practices that a worker thinks can be improved direct to the management, and they deal with them swiftly and quickly, and they have a great cooperative relationship with the SDA, where the SDA also passes that information on, and they deal with issues. So imagine if you could have that type of constructive cooperative relationship in the construction industry, which is so utterly critical to everything that happens in Australia. Every road we drive on, every major project that employs thousands of us up in the northwest. So yes, I mean that ultimately is the gold standard that we're aiming for, but we won't get there without this bill.
Thank you. Minister, we have one question here that's come through the live stream, and that is, what is the government looking for from the Australian business community in terms of its advocacy on industrial relations reform?
I'm glad that my mum listened to me and put that question in, that's good. Look, I just think, as I say, every Senate is different, and there are three layers of change that you can make. Regulatory, which sometimes requires motions of Parliament and sometimes doesn't. Administrative, there are a whole range of administrative things we can do to make the system better that don't require legislative change but require groupings of administrative changes. And then thirdly, at the top of that pyramid, there's legislative change. But the crossbench are sensible, reasonable. They might not agree with everything that the government proposes, but so long as there is an ability to negotiate and compromise and secure passage of sensible legislation, then that is the state of play that we want to maintain. But what I do find works is the crossbenchers having a sense of what the consensus is. And so if it's activists and stakeholders putting one particular view who are knocking on their door day and night, early and late, but people who might have an alternative point of view aren't organising themselves in a polite and civil way to put that point of view, then they receive an unbalanced view about what the consensus actually is. So I think peak organisations like the BCA and ACCI, large employers, you know, if you think that it would be a calamitous thing for a regulation that avoids $8 billion worth of extra cost to small, medium and larger enterprises in Australia to fail because of a disallowance motion, you need to contact the people who make that decision in a polite and temperate way. And there's nothing more powerful than doing that on a state-by-state basis. So you've got key crossbenchers in South Australia and Tasmania, and think of the South Australian and Tasmanian businesses that would have been absolutely smashed if that disallowance motion moved by Labor had got through, and where those businesses politely contact their senators who are there to represent them. That is a really, really powerful thing. So polite, structured, civil putting of rational cases, and ultimately a little bit less preaching to the converted and a bit more preaching to the wavering.